Welcome to this Caregiver webinar. I'm Lily Colby from the Department of Social Services, and we're here today to talk about resource family approval and foster youth rights. The special guests are Rochelle Trottenberg, who's going to talk about the Foster Youth Bill of Rights and the Office of the Foster Care Ombudsperson, and Kimberly Wrigley, who will speak about resource family approval process and what caregivers need to know. We also have Kendra, who can answer additional questions about the resource family approval process. Andrew, and then I'm a host, Lily Colby, and Andrew Leong is going to be talking about, providing support and technical assistance. This is a webinar in partnership with the California State Foster Parent Association, and it's our second webinar with the California State Foster Parent Association. Please bear with us if there are any technical difficulties during this presentation. We hope that you'll learn a lot as we go. In terms of webinar logistics, participants are in listen-only mode and are encouraged to submit questions in the questions section of the webinar. The webinar will be recorded and emailed to you after this webinar completes. There are multiple handouts today. If you go to the webinar control panel and you drop down to the handout section, there are 5 handouts, including copies of the Resource Family Approval Written Directive, the Foster Youth Bill of Rights, information about reasonable and prudent parent practices, and both of the PowerPoint presentations that will be conducted today from Kim and Rochelle. Additionally, please fill out the survey after the webinar completes and make sure to download those handouts before the webinar concludes. Finally, as we manage this webinar, you can submit questions to our panelists in the questions section of the webinar toolbar. We'll be reviewing those questions, and most of those questions we will take at the end and ask our panelists about. Thank you very much, and without further ado, I will pass the mic to Rochelle.
Good afternoon, everyone. I am working on sharing my screen with you. Give me just a second here. Andrew, could you invite me to share again? All right, it looks like everybody can see my screen, hopefully. My name is Rochelle Trottenberg. I'm the Foster Care Ombudsperson, and today I'm going to tell you a little bit about our office, what we do, how we can help, and then I'll cover the rights broadly and the reasonable and prudent parent standards. All right, so what is an ombudsperson or an ombudsman? Basically, an ombudsperson is an independent and impartial person that has the authority and responsibility to receive, investigate, and informally address or resolve complaints. And so basically, my office receives complaints made by or on behalf of foster youth about any concern related to their care, placement, services, or rights. And we do our best to investigate complaints and resolve them. The key is informally. We're not an enforcement body. We're here to address concerns on a case-by-case basis, and then also to make policy recommendations to improve the system overall based on the types of complaints that we get and the practice issues that we find. My office is defined in statute in the Welfare and Institution Code. So if you're a policy nerd like me, you can find them in the Welfare and Institution Code 1601. I am totally blanking. That's terrible. Well, we'll come back to that. And we have in statute some roles that we have to meet. And one is to resolve complaints. The second is we provide training on foster youth rights and the reasonable and prudent parent standards, which is what we're talking about today broadly, but you can call our office and request free training from us. We also provide foster youth verification letters to youth who are no longer in the system, and they can use those for chafee and financial aid and other programs that require proof that a person was in foster care. If a youth is currently in foster care, they get them from their social worker. We also share resources and information about services and providers and all kinds of questions. We get about 21,000 calls a year, and a pretty significant percentage of them are just folks asking for information. We make policy and practice recommendations to the legislature and to others around improving the child welfare system, and we report our annual findings to the legislature on the number of calls that we get and the types of issues that we're seeing, and then, of course, any of those recommendations. And the Welfare and Institution Code, by the way, is 16160 to 16167. So in statute, there's also some things that we can't do. First and foremost, we can't change court decisions and or case plans, but if you disagree with a court order, we will show you the route you can take to challenge that using a 388 petition process. And while we can't change case plans, if in the review of a complaint we find that there's an opportunity to re-look at a case plan, we can make a recommendation to the Child Welfare Agency to have a CFT to reevaluate the case plan and the goals, and to consider some other options. We also don't have any authority regarding personnel issues. We don't hire or fire. If a complaint goes about a social worker's conduct, we refer those to the county because that is outside of our scope of authority. So like I said, we provide trainings and workshops. As of January 1st of this year, the legislature has added the responsibility to my office to provide trainings on foster youth rights and the reasonable and prudent parent standards. So you can call us anytime for a training and we will set it up. I have an excellent team of trainers in my office. So now I'm going to transition to the Foster Youth Bill of Rights. As of January 1st of this year, a new bill went into effect, and that was AB 175, and that expanded the foster youth rights from 32 to 41 rights, I believe 27 to 41 rights, and it also added some additional responsibilities to my office, which we just briefly talked about. Assemblymember Gibson was the author of the bill, and he said this: 18 years ago, the challenges that foster youth faced were different than they are today, and it's critical that their rights evolve in the Foster Youth Bill of Rights accordingly. So we spent 3 years working with Assemblymember Gibson's office, stakeholders around the state, and foster youth, and tribes and tribal organizations to make recommendations on updating the Bill of Rights, and AB 175 captured those. So we're really thrilled that as of January this year, we have thoroughly updated the Bill of Rights. Some things that changed. One, and is an important aspect, and that's that the Indian Child Welfare Act was incorporated throughout the Bill of Rights. We also added sexual orientation, gender identity, and expression rights, also known as SOGI. Another thing that changed that I know has been an important topic amongst caregivers is that foster youth have the right to access computer technology and the internet, as well as electronic communications, consistent with their age and development. We added a law that was already in existence, but was in a different section related to the right of foster youth to have credit reports from the 3 major credit reporting agencies and to get assistance with fixing any errors or inaccuracies. We added additional education and enrichment rights to the Bill of Rights. We also added case plan and CFT rights. There's court rights and medical rights, and the medical rights include physical health, mental health, and sexual and reproductive health rights. So all of those have been incorporated, and as you can see in the attachments under the Foster Youth Bill of Rights, that's the legal language for them, which is in WIC 16001.9. That's that section of statute where the Bill of Rights lives. And pretty soon in the very near future, we're going to be releasing several publications. One is a fold-up accordion type brochure that fits in a pocket. We also have a poster to hang, and we have a handbook for foster youth. And then we're also in the process of developing a coloring book for younger foster youth, and then having everything translated into Spanish and other languages. So those publications should be coming out pretty soon. Some other things that got clarified in statute as it pertains to the Bill of Rights is that social workers now must review these rights every 6 months and at every placement change. So that's important too, because that means if you're accepting a new placement as a caregiver, the social worker should be providing you with that foster youth rights, as well as discussing it with them in a way that they understand. So that every placement change is the addition that happened this year. Before, it was just every 6 months. In conjunction with the Foster Youth Bill of Rights is this concept of the reasonable and prudent parent standard. So the reasonable and prudent parent standard is simply this concept that allows parents to make reasonable decisions for their children that allow them to have a normal childhood experience in a very abnormal system, which we call foster care. But basically, the definition is careful and sensible parenting decisions that maintain the child's health, safety, and best interests while encouraging the child's emotional and developmental growth. A caregiver shall use the reasonable and prudent parent standards when determining whether to allow a child in foster care who's under the responsibility of the state to participate in extracurricular, enrichment, cultural, and/or social activities. So they have the right to do those, and how that happens is in the context of parenting decisions. So some factors that you would want to consider in making reasonable and prudent parent decisions is the child's age, what their different abilities, their maturity, your history with that child, not necessarily just their past history or behaviors, but what you know about them and what the relationship that you've developed in that history with that child in a relational context, input potentially from other service providers, your own parenting experience, length of time that child's been in your home. Again, you could consider past behaviors. That shouldn't always be a barrier to, future participation in social and developmentally appropriate activities, any known precautions, and there may be other relevant factors to consider. So what do you apply these decisions to? So these decisions are the day-to-day routine.
I think I lost Rochelle. Rochelle, I'm having trouble hearing your audio. Is anyone else having trouble with the audio temporarily?
Are you able to hear me? Hi, this is
Yes.
Kim Wrigley. Okay.
We lost Rochelle mid-sentence. Yeah. I'm not sure whether she can log back in and continue from where she was. If she doesn't log back in at this moment, we could switch to your presentation, Kim, if you're able to do that, and then switch back to Rochelle when she's able to get back on.
Yeah, I can do that.
Oh, it looks like
It should be Rochelle.
it looks like Rochelle is going over the handout and may not know that we've lost audio. Let me see if I can get through to her to continue the presentation from where she left off. Wait 1 second. Since we can't get through, she's calling back in. I can explain a little bit about what she was about to show, which was a document about the reasonable and prudent parent standards. Additionally, a number of people have written into the question section that they had trouble with the audio in the first 15 minutes, so I'll repeat a couple of the announcements that I made. During this webinar, you can use the control panel, which allows for questions. If you submit questions, not just about audio, but about anything around the presentation, you can put them into the question toolbar, and we will ask those questions at the end of the presentation. Additionally, we're going in order, first discussing foster youth rights, and then talking about the resource family approval process. We're excited to have so many foster caregivers and those who support foster parents and resource families on the line. And I believe we might have Rochelle back on the line. Rochelle, can you hear us?
I can hear you.
Great. You cut off before you started showing the reasonable and prudent parent document. About a minute before that, we lost you. I know you were probably speaking and presenting, but we didn't get the opportunity to hear what you were saying. So if you could start back
Sure.
For that slide. Thank you very much.
Okay. So did you all hear this one, the definition?
No.
Okay, so I'll start at the beginning of this section. My apologies, folks. So the reasonable and prudent parent standard is simply giving caregivers the opportunity to make day-to-day decisions that are in the child's best interest. And this is something that's changed over time, but now is required by both federal and state law. So it's basically a careful and sensible parenting decisions that maintain the child's health, safety, best interest, while encouraging the emotional and developmental growth. You can use this decision-making, this RPPS, to allow a child in your care to participate in extracurricular, enrichment, cultural, and/or social activities. Some of the factors that you would want to consider is age, ability, maturity, history, like your own personal history with the child, input from other service providers, your own parenting experiences, the length of time that child's been in your care, past behaviors of the child, though you don't want to always use those. They should, in decision making, we want young people to learn, but you do want to consider them. Known precautions and other relevant factors. So these are the things you would consider in decision making. The reasonable and prudent parent decisions or standards are really about giving children in foster care the opportunity to have normal life experiences so that they get to experience what other youth experience that are not in foster care. So our PPS decisions apply to those day-to-day routine and typical decisions: chores, television, homework, going out in the neighborhood for a walk, riding your bike, going to the park, with friends. These are all our PPS decisions. And they apply to participation, again, in those age and developmentally appropriate activities such as school, extracurricular things, sports, social, cultural enrichment, opportunities, field trips, and similar activities. So the document that is from the Youth Law Center that's in the handouts is great because it covers lots of different topics that are frequently asked questions for caregivers. And what's different about this is in the past for caregivers who've been doing this for decades, they know that back in the day, in order for you to make any decision about a child, you either had to have the social worker or the court's permission. And that was for normal things like going on a field trip or having a babysitter so that you can have date night, those kinds of things. And now you can actually have like a trusted adult that you know watch your children for date night. You don't have to go through the background check. You can also do things like letting the child participate in sports programs, et cetera, at school, where before, again, you had to jump through lots of hoops to make that happen for young people. So this is really about empowering caregivers to make day-to-day decisions for young people so that they get to grow up with all those healthy life experiences. So there's a few things that you cannot make decisions on as a caregiver, or where that RPPS, the Reasonable and Prudent Parent Standard, doesn't apply. One is visitation. Obviously, that's court ordered and mandatory. You don't get to say they can or can't have those visits. We all have to comply with those court orders. Medical decisions. Again, of course, if there's an emergency, you are making medical decisions and you're taking that child to an emergency room and notifying the social worker. But generally speaking, parents still have the right, and it's, I think, best for everybody when caregivers are involved in engaging parents in medical care for their children. Physical or emotional discipline, obviously, that's never okay. Returning children to their parents without court approval, you can't do that. Any kind of change of schools is not something you can do. If you're the education rights holder to that child, that's a different, discussion. But if you don't hold ed rights, you don't have the authority to move a child to a different school. IEPs, again, if you're not an ed rights holder, you're not really able to sign an IEP. You can't do anything to drastically change a child's appearance, cutting their hair, piercing their ears. We had a case recently where a caregiver circumcised a baby. That's also considered a drastic change. You can't do that. Medications, you can't give a child psychotropic medications without court approval. You can't stop them without court approval, etc. But there are some, flexibilities in terms of, like, if you have a baby and you're giving them something to reduce the fever, right, that's over the counter. You can't change a child's religion. You can't have babies baptized, etc. Again, it doesn't apply to general court orders, and RPPS does not apply to sibling visits. That's a right that children have. Again, this is really all about helping caregivers be empowered to make reasonable and timely decisions that assist in the continued well-being and development of children and youth in foster care, and then instead of having to navigate multiple levels of court and social worker approvals. So we're empowering you to take care of kids. And second, the paradigm shift is really about safety remaining a priority, but considered in the context of age and developmentally appropriate activities. So I know we're going to take questions at the end, so feel free to put them in now or later. If you need to reach our office because you have a concern about a child in your care, or you want to request a training from our office, you can call us on our hotline, which is operated from 8 a.m. to 5 p.m. 5 days a week, or you can email us at fosteryouthhelp@dss.ca.gov. And you can also go on our website where we will post the Foster Youth Bill of Rights. We've been posting some updates related to COVID-19 and foster youth. And on our website, you can also, if you have a child in your care that's 13 or older, you can download an application through iFoster to help your child get a cell phone that comes with free talk, text, free Wi-Fi hotspot, and free data. And that's a 2-year plan for youth. So there's also great caregiver handouts related to cell phones. So I know that's a hot topic, but I'm going to stop there and turn it over to our next presenter. And Kim, it's coming to you.
It helps if I take my phone off of mute. Let's see. Oh, give me a moment while I figure. I'm not very good with technology here. Can folks see my screen?
Yes.
Okay. Oops, now I need to do that here. Okay. So yes, thank you. I'm thrilled that we can do this webinar today, and I'm a little bummed that we can't do it in person. I do miss seeing everyone's faces. Over the years, I've gotten to know several of you, and I'm hoping when we do see again, I can meet many, many new resource families out there. So thank you for joining us today. I'm going to do just a brief overview, a little bit about what is RFA. And then in light of the pandemic and the world we're currently living in, I'm going to talk just a little bit about where, some of the executive orders that have provided some flexibility or waiver of some of the standards and rules related to the Resource Family Approval Program. So I guess I probably should have turned to this slide first because that's where it's explaining what we'll be going over here. So, and like Rochelle, at the end, we'll make sure we have an opportunity for people to ask questions, and just, really wanting to stress throughout today's conversation that one of the big changes and things we continue to advocate for through the Resource Family Approval Program is the partnership with everybody on your team, from your county social workers to the child social workers to the health professionals, to everybody involved in you and the child's life, to be asking for help and working together so that we can be sure that you are getting everything that you need, which ultimately helps support any children placed in your home to succeed and thrive. This may be a little bit of old news for some of our folks that are participating in today's webinar, but I'm hoping we have many, many new or potentially prospective resource families that are going through the process now. So just want to talk a little bit about what resource family is. It's still fairly new, even though we've been working on it for several years now. But effective January 1st, 2017, anybody interested in providing care to a child in the foster care or probation systems will now go through the RFA process, which eliminated all these former licensing or approval processes that were separate depending if you were a relative or a non-relative, very duplicative if you were seeking to provide permanence to a child in your home. So RFA really eliminated all these duplicative separate standards for families, and it created this one unified standard that not only looks at your home and the people residing in your home, but it also provides enough of an evaluation and assessment of you so that if you choose to move forward to a type of permanency, that you won't have to undergo an additional approval process. So it's one single unified approval standard for all types of care for children, again, in the child welfare or probation systems. And it really provides, for families going through this process, it really helps provide the county or the foster family agency a very comprehensive look at the resource family, and that includes interviews, it includes a final report, and it really helps the people involved in the family's life understand what are a lot of the strengths that the resource family has, what supports do they need to help them continue to grow and evolve those strengths, and where are some areas where maybe the county or the FFA might want to do some more work with the family and help build up an area where maybe they don't have a lot of skill or knowledge in yet. So where can we provide better support and more room to grow there? RFA also now prepares and it trains family to meet all the needs of children from the very start of a child's journey. Previously, if you were a relative, there was no training requirements for you as you went through your approval process. And that really did create a discrepancy in skills and standards with families, because some folks got a lot of training and education and coaching and mentoring, and some did not. So with RFA, where training is required for everybody, you have that knowledge and preparation ahead of time, which ultimately is going to continue to help support all children placed in your home. And it also helps prepare you if, as a relative, going through the process, if down the road you chose to continue being a foster caregiver to other children in the system, that you have all of this knowledge and training now in your wheelhouse, so that you could also take placement of non-related children. And that's been a very exciting thing we've seen with resource family approval. And as you go through it, it really is helping us understand how can we better support a permanency plan for the child. Resource families continue and will always have the choice in what type of care they want to provide, whether it's temporary care through fostering, or if they do ultimately want to look at a more permanent role in a child's life, they have the right to choose that. But RFA helps assess where you may need more support or what skills you already bring to the table for permanency. I do always like to stress here, because we do get a lot of questions about it, that the resource family approval process, it's the process to approve the family. It does not guarantee any placement decisions, whether it's an initial placement or ongoing placement in a temporary or permanent capacity. So placement decisions have always been and do continue to be a separate decision that county workers are in charge of. So even if you are approved as a resource family, the placement worker still has to determine if you're the appropriate family to meet this specific child's needs. So we do get a lot of questions about that. So throughout the process for our prospective resource families, you'll only have one application you need to fill out, one background check, which for families who are familiar with the older processes, this was very exciting, because if you were going to adopt, you had to do more than one background check, and sometimes those background checks can take quite a while to complete. It combines a home safety check, the family evaluation. It has pre- and post-approval training for all of our families. And it even allows for the ability to receive placement of a child before you are approved as a resource family. And that can be through the emergency placement process if you're a relative or a non-related extended family member. With the emergency placement process, to receive that placement, you would undergo a name check, a criminal background check, and then a check to see if there's any child abuse allegations against you, and then just a real quick inspection of your home to make sure there's no immediate health and safety risks to your home. And if all of those are met, then you could receive placement, and then you would start the RFA process within 5 days after receiving that emergency placement. Compelling reason is a little bit different. It allows anyone, related or non-related, to receive placement prior to approval once certain components of the RFA process have already been completed. And that would be the full criminal background check, and if there was any criminal history, we call it exemptions, but any exemptions were granted that basically say, yes, there's some criminal history, and we do not believe it precludes them from being a safe and appropriate resource family. So those would be completed, as well as the home, the check of the home. That would be a little bit different than the brief home check done through an emergency placement. The home check under compelling reason is a more thorough check of the home, where a form is completed by the RFA worker and signed by the family. So if those are completed, then you could receive a compelling reason placement. And then again, you would continue on with the RFA process. And continue on with that. I'm sorry. So this is just, we found to be a really helpful visual aid to help better explain everything that I just stated. So you can see there's basically two big umbrellas under RFA. So if you guys could see me, I'm doing a lot of hand motions and I'm pointing to areas of the screen, and I keep forgetting nobody can see me. But under the home environment assessment, you would complete the background check and that home health and safety check, which is what I was just talking about. That's the area that would need to be completed before a compelling reason placement could occur. And the other big umbrella is the Permanency Assessment. And under that is where the interviews of the family would occur and the training. And when you have all of those completed and you've submitted your RFA application and any other supporting documentation, that really forms that comprehensive assessment of the family, and that is then summarized into the written report. That written report, a family is required to receive a copy of it. So once you are approved or denied even, at any point in time, approval or denial, families have a right to the written report. So if you've not received one, you can absolutely contact your RFA worker and request one. And that written report may also be shared with placement workers to facilitate a placement match. So if you're being considered for placement of a specific child, that child's worker would have the ability to review your written report to make sure that it seems to be an appropriate match. So to really have a thorough understanding of RFA, there's places you can go and really get the nitty-gritty and all those detailed information. And that's through, if you're with a county agency, through the written directives, and if you're with a foster family agency, it's through the interim licensing standards. They're mostly the same. There are a few differences that are unique to a public versus an FFA type of agency, but the approval process is almost entirely the same, whether it's a county or FFA. And they're considered regulatory documents, which means these are the requirements that all counties and all FFAs must ensure a family goes through to become approved as a resource family. So it outlines all the processes, standards, and requirements. And abiding by the written directives or interim licensing standards is not optional, it is required, and they're developed based on laws, based on the statutes. So we've got a lot of great things that I think have really helped build our RFA program, and there's a lot of wonderful information in there. And as of March, some of those approval standards have become a little bit more difficult to follow right now. So we have worked really hard, and the governor's office has worked really hard to ensure that we still have resource families available. The need for resource families is greater than ever right now as we go through this pandemic, but we want to make sure that there is nothing in our standards that are prohibiting us from moving forward without jeopardizing the health and safety of any children ultimately placed in a family's home. So how do we do that and make sure that we that health and safety is still looked at? So there's been several executive orders that have been released, and as a result of those executive orders, we have sent out letters to the counties. We call them ACLs, and for FFAs, there have been what's called provider information notices that explain where we've been able to temporarily waive some of the requirements. So I'm going to basically focus on the newest flexibilities that have occurred effective, effective July 1st. So there's been so much happening. I'm sorry, I had to think on that. But with RFA, there are interviews that are required to be conducted in person of the applicants and of all the adults and children in the home. So for a long time in the written directives, other adults in the home, if they were not able to be interviewed in person, we always had the flexibility that they could be done by video conferencing. That was not allowable for applicants or the children in the home. But currently through our ACLs, we actually have another one that we believe will be posted, if not this week, then probably more realistically next week, that will outline this in more detail. We still encourage counties and FFAs to do the visits in person, but if that's not possible, then a visit can be conducted through a video conference, and only video conference. It's not telephonic. And these interviews, that does not count the inspection of the home to go through the home health safety assessment. That actually has to be done in person, but the visits could be conducted by video conferencing. There may be some situations where that's just not possible or safe for the family or for the worker to do that visit. And if that's the case and there's not a creative solution, such as interviewing somebody in the front yard or meeting in the backyard, if there's not a creative solution to still do that visit in person, then you can do the video conference. And if you're not able to do any of that, then that would be documented in your file, and the county would then, it would delay the approval of you as a resource family, but the the interview could be delayed until until it was safe to do so. We've also temporarily increased what we call the capacity of how many foster children could be in the home. Previously, we said that there could be no more than 6 children, whether it was foster, biological, adopted, residing in the home, unless there were a few exceptions, maintaining siblings together, a parenting youth. There's a few exceptions to that rule. But our flexibility has now opened up that capacity that you can have up to 6 foster children in the home and not worry about the count of the other children in the home. And the exceptions still apply. But it's really important to note that if people with this capacity flexibility, the family still needs to be determined able to care for the number of children being considered. And when the executive orders do expire, the previous standards do go back. So if you did have, let's say, 8 foster children placed in your home, and there was not a, let's say 7 foster children and a couple of biological children, we would have to go back and look at that capacity, and it could require some placement changes once the executive order expired. We also have standards about how many children can share a bedroom and common area spaces, and we've provided some flexibility in terms of that. We know that if some reason there is a child or an adult within the home that does test positive for COVID or was exposed to COVID, that, hopefully we're not needing to make placement changes because the exposure likely happened to everybody, but you will need to isolate the person. So how do we do that in a safe way if there's a limit on bedroom space? So you could end up putting more than 4 children in a room, again, as long as it's not jeopardizing anyone's health and safety. So we've got some flexibility around that. The pre-approval training, we require a minimum of 12 hours of pre-approval training, but if there's no feasible way for a family to receive that pre-approval training, whether it's in person or online, and there's no other way to receive that training, and all the other components of the RFA process have been completed, the county or FFA could provisionally approve the family as a resource family, and then they would have extra time after they're approved to complete that pre-approval training. And there is a time limit on that, and failure to complete that training could, I'm going to say could, not would, could result in your approval being rescinded. But there's a lot of flexibility around that, so we don't anticipate that being any issue. Complaint investigations. Previously, we did have some executive orders that allowed some flexibility in terms of doing complaint investigations by phone or by video conferencing, as long as it was not a serious incident or serious complaint investigation. We did recently release an ACL that is encouraging those complaint investigations to occur in person again. There are still some exceptions to that, again, basically when safety is a concern, but for the most part, that executive order, some of that flexibility has been minimized, and counties are strongly encouraged to resume that to be conducted in person, unless some of the exceptions that are outlined in the ACL are relevant there. Annual updates. I think families may be pretty excited about this one. We had actually prior to June 30th, created some flexibility with extending the time that an annual update could be completed during this period of time. But actually, we had a bill that was just chaptered. It's called Assembly Bill 79, and it went into effect July 1st. That has changed the annual update to biannually. So we don't really need any flexibility in terms of the state of emergency we're currently in right now, because that has already, just as an RFA standard, been changed. So updates have to be completed every other year at the most. If you do move or there's a significant event that's happening in your life, you would still conduct that update within that 2-year period. But if everything's just kind of moving along and there's no significant changes occurring and you haven't moved, it's now biannually instead of annually. The training, though, the post-approval training is still required to be done on an annual basis, but the full update now would be every other year. So I think that will be really helpful to families and counties and FFAs as they deal with a lot of the challenges of going through this process right now. So just some quick helpful tips, recommendations. You know, the communication between your worker, the county, the child's worker, everybody involved in your team is more important than ever. I don't think any of us can stress this enough, how important communication is at all times, but especially right now when so much of our world is being conducted and our business through remote means. So, you know, just checking in and saying, hey, just wanted to say hi to you. I'm doing, you know, things are going okay. I could use some help with X, Y, or Z. Just really encouraging to maintain all those connections. And we do have a lot of wonderful resources that are available out there if you do need help. There's the Family Resources Centers that are based throughout the regions. We have a 211 helpline. There's a lot of local support groups. So if you're reaching out to your foster parent association, you know, check with your peers there if you're looking for some support groups in your areas. Child family team meetings continue to occur, so participation in those is so vital, again, at all times, but almost even more so. There's so much information and value you bring to the table. Your contribution is vital to supporting any child placed in your care. So if you need help with accessing any of these resources, you know, feel free to contact us at our RFA inbox. I think we probably forgot to, oh yeah, here we've got some of our resources, sorry. You can always contact us at our resource family approval mailbox. The address is right there. We have the COVID-19 website that's all got a lot of information there. But if you're struggling to find something and you need some help, you can use any of these mailboxes or reach out to anybody. We will get you to the right person to help support you with anything you need at this point in time. And I think that's it. So I think I turn it back over to you, Lily.
Well, we can start with maybe having you answer some of the RFA questions, and then we can turn back to Rochelle. If you go to the question section of the toolbar, you can see a number of questions. I can start with asking a couple of the broader questions. Could you explain a little bit more clearly the difference between placement and RFA approval? There were some questions about, well, if a relative gets preference, do they get preference in the RFA process, or do they get, how does that work? So if you explaining that a little bit.
Absolutely. And Kendra, please feel free to chime in here. And that is a very important, very, very important question, and one we get a lot because it is a little confusing. In the old world before RFA, the relative approval process kind of merged those two worlds together, and RFA has separated it out. So absolutely, the laws and just our own, the CDSS mission is to support relative placements wherever we can. So what that means is the preference is relatives that have come forward, or we must seek out relatives. They have a right to be considered and they should be considered. And what that means is we still have to go through the RFA process, but we still have to determine if that relative is an appropriate placement for that specific child. But it's making a placement decision, whereas the RFA process, oh boy, I don't feel like I'm explaining this very well today. The RFA process is looking at you as your family as a whole. So it's studying your criminal background history. It's looking at your home. It's really getting an understanding of who you are and what your family is, and what your strengths are and where you need more growth. The placement decision is, and so you could be approved as a resource family, but now the placement worker is going to look at that information and say, is this the right placement for my particular child? And yes, as a relative, you do have preference to be looked at and considered first. But if there are maybe you met all the standards, but the placement worker has some concerns about whether or not you can meet certain standards, that's something that they would have to address via the court means. Kendra, I don't think I'm explaining that very well. Do you have anything you'd like to elaborate on?
Sure. I think, like you were saying, just because a family or, a relative is approved for placement, the placement worker, the RFA worker has their role of looking at you as a family, and that is their kind of scope and their lens. And then you have the placement worker who has their lens of the best needs of the child and what the child's needs are, and what the best type of placement for that child is. So even though you're approved, the placement worker might determine that, the child needs, just going to throw something out there, 24/7 support, but you and your spouse or you and your significant other work full time and aren't able to provide that care, that support for the family. The placement worker might think that isn't the best placement for them. But as Kim said, relatives always have the placement preference, and relatives should always be assessed for placement. And that leads me to something else. Is sometimes we get questions about, a child is detained and they've entered dependency, and 10 relatives come forward. The child can only be placed in one placement. So we really encourage the counties to hold a child and family team meeting to just really talk about with everyone involved, who the best option to move forward with RFA approval is, and then how everyone else that's involved in the child's life can support that child, maybe providing respite or maybe having overnight visits a couple times a month. We still want to keep everyone involved, but also looking at resources and time for everyone, who would be the best kind of option to move forward.
Thank you. Additionally, there was a similar question around getting approval through RFA and it being unclear about whether or not that meant that a caregiver could then adopt the child later. I think your explanation helped clear up that the resource family approval process doesn't mean that you will get placement or adoption decisions later.
Yeah, with the adoption part, you are still approved for all types of care, but there still needs to, but the placement worker, even for adoption, still needs to look at, if you are the right match for this particular child. I was trying to think of a metaphor, and maybe it's a job application that you met all the standards for a job and you're eligible for a job. So you're approved to move forward with this is not the best metaphor, I admit it, but you're approved to move forward with the interview process. But on the other side, the person interviewing you is trying to determine if you are the right fit for this particular job, even if you met all the standards. I'm not sure that's the best metaphor, but trying to think of something off the top of my head to help illustrate the point a little bit more.
And we have some questions about the current standards. Some of the standards have changed right now. Two of the questions have to do with the changes in those standards. One is, if additional children get placed in a home, will those children get removed? once the COVID emergency ends? And another question is, with the additional leeway, will teenagers who are returned to home, who are adult teenagers who are normally in college, have to go through background checks during this time? Those are two current changes that folks would like to know the answers to.
So if a teenager who's 18 has moved back to the home, that rule has not changed at all. Anybody who's residing in the home who's 18 or older will need to go through a background check. So yes, if they've moved back to the home because their college is closed, or whatever the reason being, or somebody's lost their job and they've moved back home to help with finances, yes, they would need to go through a background check. And the written directives or interim licensing standards have a pretty thorough section to help explain that. I forget the other part of the question.
It's going over capacity, the waiver capacity.
Oh,
yes,
yes.
The question.
Go for it, Ken. Yeah. Yeah, go ahead.
So if a child is placed in a home and they use the waiver flexibility that's currently in place, once the pandemic is over and the state of emergency is over, then yes, that child or youth would need to move to another placement to bring that home back into capacity if there was no other available space. So say they had another foster child in there, but they left and now there was room, they could stay. But if the family was still over capacity at the end of the pandemic, then yes, they would need to relocate to a different placement.
I think it's important to understand that these waivers and flexibilities are to meet these pandemic needs and to find creative solutions to address some of the issues that have come about as a result of the emergency. But when the emergency ends, we are required by law to go back to the standards, the more permanent level standards that are discussed in the written directives or interim licensing standards. But if you are making use of these standards, such as the capacity one, we do strongly encourage, and this will be coming out in a letter that will be released soon, to be concurrently working on what will be the plan for these children in the home. We don't want it to be an abrupt transition. We want it through the child family team or other means to really have a clear idea of how that transition will occur, so it's minimizes any impact on the child or the family.
Thank you. I think we should turn to Rochelle for a few questions, and then we might get back to additional RFA questions. There are a lot of questions in the question section. If Kim and Kendra, you want to start answering some of those by writing answers or thinking about answers, but I'll take some foster care rights questions that folks had for Rochelle, if we can get Rochelle back on the line.
I am on the line.
Great. Some caregivers had trouble hearing the beginning of the presentation. Do you mind explaining again a little bit about what your office does and why caregivers might contact your office?
Sure, I'd be happy to do that. So my office is an autonomous or independent office within the Department of Social Services, but with some protections for the nature of our role. And we receive, investigate, and informally resolve complaints about any issue related to a foster youth care, placement, services, or rights. So we get about 21,000 calls a year, and our job is to provide information to folks and then also to look into cases. In statute, my office has the authority to decide whether or not we're going to investigate a case or not. But every case gets an intake completed, so you'll call and tell us about what the issue is. You'll talk about, my staff will ask you questions, we'll ask you who the social worker is, we'll ask you also to tell us what it is that you're seeking as a resolution, and what attempts you've made to try and resolve whatever the issue is prior to calling us. Then we go through a screening process where we look at the case, we look at what the requested outcome is, we will look at the child welfare case record, and we make a determination if we're going to investigate or if we're going to refer you to a different agency or route to address your concern. But again, caregivers, I believe, are our second most frequent caller, and they, are calling usually related, again, to issues related to the care, placement, services, or rights of foster youth. We also provide trainings on foster youth rights and reasonable and prudent parent standards. We provide youth who've left foster care, who are no longer in care, with verification letters that they can use to get access to CHAFE and financial aid and other programs for former foster youth. And then we also make policy recommendations. So that's the nutshell of what our office does.
Thank you. So there were a couple of questions about the Foster Youth Bill of Rights itself and how youth access it. Is it the placement social worker for the county or the foster family agency that provides foster youth with a copy of their rights? And how often are they supposed to do that?
Great question. So right now, the county social worker has a legal obligation to review the rights with the child every 6 months, which is usually aligned with their, 6-month court hearings. And this changed as of January 1st of this year. A social worker must review the rights with the youth at every single placement change, and they have to do it in a way that the youth understands. And if the youth is 14 years of age or older, they actually have to also get the youth's signature, and they need to document that they reviewed the rights with the youth. Foster parents are also supposed to be given the rights of foster youth at placement. They're usually in the placement binders. And FFAs, I believe, also have a responsibility to inform the caregivers about and train caregivers about the rights of youth in foster care.
So if a caregiver hasn't accessed these foster youth rights at a placement change, should they talk to you or their social worker? We've attached the rights for everybody here on the line. They're available online. They're also attached as a handout. But if caregivers who are helping support newer caregivers and those caregivers don't have access to the rights, what should they do?
The rights are posted on our website, fosteryouthhelp.ca.gov, and also you can request them from your FFA, you can request them from the social worker at the county. Additionally, our office is very close to releasing 3 new publications, and we have a couple are still in process, but one is a handbook for youth that goes over their rights. The second one is a poster which can be posted in homes that have 6 or more children, or STRTPs. That's, I believe, consistent with what the law currently is. And then we also have an accordion fold brochure that fits into a pocket. So it has like hard cardboard like outsides to take some wear and tear from being placed in a pocket. Those are going to be available in English and Spanish, and we're set to release them soon. We're also in the process of developing a coloring book for smaller children. So it's something that caregivers can go over with kids and social workers as well with the younger ones. And I have to say, when we were doing focus groups with youth and the coloring books, the teenagers were just as excited about the coloring book. So that was kind of fun. And then we're also developing a brochure that will be specific to Indian Child Welfare Act youth who fall under those protections. And then we're currently partnering with another organization to develop an LGBTQ specific rights materials.
Wonderful, thank you. There were a number of questions as well about the reasonable and prudent parent standards. We might not be able to get through all of these questions, but some of the questions had to do with whether over-the-counter medications could be administered to foster youth with within the reasonable and prudent parent standards?
I can look up, I'll have to look that up, but, you know, also each county does it a little differently, and Kendra and Kim, if you have anything you want to add related to that. One thing that I will say is foster youth have the right to refuse medications, even ones that have been approved by the court, such as psychotropic medications, they have the right to refuse that. And so, you know, you do have to respect their right. And certainly if, you know, you had a baby that had a fever and you went to the doctors and they, you know, said it's okay to give the baby, you know, baby fever reducer, I don't know what the medicines would be, then, you know, you're following a medical doctor's directions, and you would obviously get that in your, you know, in the paperwork you get for discharge. So
thank you.
Consult with your FFA or your county.
Thank you. Yeah, it might be a case-by-case basis. There were some specific questions that were asking more detailed things about whether or not they fell under the resource family approval process. I mean, whether they fell under the, I'm tripping over my words, the exceptions and the guidelines for caregivers about reasonable and prudent parent standards. And some of those examples were probably too detailed for us to cover in this webinar, but are questions that you can ask either the county or the FFA social workers. In terms of the Foster Youth Bill of Rights changes, what do you think are the biggest changes that caregivers should be aware of? You covered many different changes, but were some of them things that caregivers didn't know about and might need to know more about in this next year?
Well, all of these rights went into effect as of January of this year, and I would say that I think the things that are important to be aware of is, again, for example, the right to have food, clothing, that has always been the case. This year, we made a change in terms of allowance, so you should be consulting with your FFAs around the allowance. Prior to January 1st of this year, only youth in congregate care settings had a right to an allowance. And now all youth have a right to an age-appropriate allowance. The other thing that changed that I think is important for caregivers to note is that issues around grooming and hygiene products must respect a child's culture, ethnicity, and gender identity and expression. So if you're caring for Black children, you should absolutely be ensuring that they have hair and skin products that are appropriate for their hair and skin. If you have gender fluid or transgender young people in your home, you also need to respect their gender identity and expression and provide them, again, with clothing, grooming, and hygiene products that reflect that. Other things that I think is important is there was a section added to the Bill of Rights, which means that caregivers will have to have special training going forward because there's a right to have a placement that utilizes trauma-informed and evidence-based de-escalation and intervention techniques, and to only have law enforcement used as when there's an imminent threat to life or safety. So I think that that's a major one where you can't also tell a child I'm going to call the cops as a threat or as retaliation. So, caregivers should be talking with their training agencies to ask about where they're going to get that training from. Some other things that I think are of importance to caregivers is the right for young people they already have the right to send and receive confidential phone calls, but now that includes other electronic communications, so emails, text messages, etc. Of course, this is where the RPPS intersects. If a child's doing something that's really inappropriate and sending, inappropriate photos of themselves, for example, there would be a reasonable and age-appropriate consequence that might temporarily prohibit that, but it's not something where you can, across the board, deny a youth access to electronic communications. The other thing that I would say is important to note is the right, again, to access computer technology and the internet that's consistent with the child's age, maturity, and developmental level. Especially now during COVID, but even before, we live in a world that is very much web and technology based. And so foster youth also have that right to have access to those things. And for those folks that are way, way, way up in the far northern rural parts of our state, where there is no internet, where there is no phone lines, or cell phone towers, I think that's where we can talk about how do you, is there a place in the community? Are there places, family resource centers or others, or at school where a child can get access to those things if they need them? So we have heard that before. We do know that's an issue. But again, that's a big change that was added this year.
Wonderful. I think we should maybe send it back to Kim and Kendra to answer some more resource family approval questions. And Rochelle, you have the capacity to look at the questions. There are a few more foster youth rights questions in the question and answer section, but anything not answered today, we'll try to email the answers to caregivers who ask these questions today. We'd like to get back to each and every one of you. Thank you, Rochelle, for answering all these questions and for talking to us today about the work that your office is doing, supporting children and families across the state now and before this crisis. It's wonderful the work that you do, and we're very appreciative to have you on the line today. Thank you. Kim and Kendra, there were some additional questions.
Oh. Yes, there are.
There are a lot of questions about RFA.
I know about it, and I'm having a hard time seeing them in order here. So I'm looking at one right now, and Lily, please feel free if I'm accidentally skipping over any here. I'm looking at one right now. It says, if someone was denied a placement, should they renew their RFA license? Will they get other placements? And absolutely, just because you were a placement worker decided that you may not have been the appropriate match for that particular child. As a resource family, we definitely encourage you to maintain your approval. You could be considered for other placements. So just because and it may be a variety of reasons, just because you were not considered appropriate for one particular placement does not mean that other workers will not think you're the best family on earth to care for their particular child. It could be sometimes a variety of factors. It could be maybe a child was discovered to have some Indian heritage, so they needed to go look at the ICWA placement preferences, and you had no Indian heritage in you, so sometimes that could be a factor. Or maybe the child, there was a lot of maybe they were a victim of commercial sexual exploitation, and so the needs that child required are very particular, that perhaps that you did not have that skill set for. So there's a variety of reasons why it may be determined you're not the appropriate placement, but that does not negate your skills and ability as a resource parent. So again, that's, I think where a big difference is. So definitely keep up your approval there. And yeah, Lily, if I've skipped over things, please, help me out there.
So there are a number of different questions, and let me see where we can go from here.
Some of them are kind of similar, so I'm trying to be respectful of the time there with that.
Could you explain a little bit about, let's see, there are a number of questions. If a family hasn't received a call for placement, should they consider to renew their license? One question was, is it normal to not get a call for 18 months? It's
really, it's hard to say without having more information. Sometimes it depends on if you indicated the types of children you felt you were best suited for. So if you said sometimes if you have a very narrow interest in children, for example, you're only interested in babies, 0 to 6 months old. It could be that the county hasn't been able to contact you because those babies have been placed with relatives. There's a whole variety of factors, but if you've not heard from your worker in 18 months or you've not received any calls, I would definitely, encourage you to call your resource family worker and have a conversation with them to help discover what the reasons may be that you're not getting the calls. Absolutely. So if there is maybe something accidentally, maybe something that you indicated earlier is no longer true and they just need to update the system. There's so many factors, or maybe there is something that the placement workers have noted that this gives me a little bit of pause here, and maybe it's a training, maybe you just need some more training in a certain area. So definitely call your worker and find out what's going on there. Absolutely.
One question, if you have the capacity and means to care for more children during this pandemic, who do you need to let know?
I would let your RFA worker know. What they would be able to do then is go into the database system and amend that. So that would be a conversation to have with the resource family worker.
If families have questions, what's the best email to reach the RFA unit?
RFA@dss.ca.gov. We have a person that mans it during all business hours, and she's got a really wonderful tracking system to ensure that we don't lose questions. And we usually have a pretty prompt response. And that she's very good about making sure they get forwarded to the appropriate people. That really is probably the best way for any type of RFA question to reach us.
There's another COVID-19 related question. If a child is exposed or tests positive for COVID-19, will this information be disclosed to the RFA parent?
And it's a child placed in their care. I don't know. I'm not an expert on the HIPAA related rules or laws, but I do believe I believe that there is a need to, because as the resource parent, you would have been exposed to the child. And so you yourself may have to take some safety precautions. What we could do though is I don't want to give a definitive answer unless someone else on the phone has a definitive answer. That one is something we could follow up on.
This is Rochelle. If a child was previously diagnosed and has tested and is no longer positive, that I would argue is protected health information, and so you wouldn't necessarily be entitled to that. If a child is actively positive, and you're willing to take placement of that child, absolutely, you would know that. My understanding so far is that there's been actually a number of caregivers who have, taken in positive youth. I also know of families, foster families, where caregivers have tested positive, and they've maintained the children in their care during that time. So it certainly is difficult. If the county actively knows a child is positive, they would have to inform you, because the whole house would need to be quarantined, and you would be exposed by the nature of caring for this positive child. But if they're no longer positive and they've been cleared, yeah, it's not it's protected health information.
I 100% agree with that. Yeah. Yep.
So if it looks like there are a number of other questions, but we might not be able to get to all of them. Some of them have to do with how to contact you, and you've shared that it's fosteryouthhelp.ca.gov to reach the foster care ombudsperson office. And then the number again. Rochelle, do you know that off the top of your head? That was another question, how to reach out.
Yeah, it's 877-846-1602. And in the PowerPoint, it's saved as a PDF on the handouts for this webinar, and it's the second to last slide has that information. But our hotline is the best way to get a hold of us, and that's 877-846-1602.
And what are your hotline hours during this time?
We are open Monday through Friday, 8 to 5. For the months of April, May, and June, we were operating 7 days a week, 8 to 5. We were open on the weekends, but as of June 31st, we are not operating weekend hours at this time, and we're monitoring the COVID situation to determine if reopening weekend hours is beneficial to foster youth and caregivers.
So Lily, I'm also seeing some questions about resource families and participation or lack of participation in child-family team meetings. And so I think there's some great questions about that, but I'm probably not the most appropriate one. I'm not sure if anyone on the phone has the email box for our child-family team experts. Child-family teams are still fairly new. And so I think a lot of counties, there's a lot of guidance that's been provided, but they're still trying to learn and implement how we bring resource families to the child-family team table. So I do know there's been, in different areas, some lags in ensuring that happens. But that's where, we have some other folks that would be really helpful to help you answer those questions. Rochelle or Kendra, do you know what that's the email would be for questions about the CFT?
I just emailed or texted someone to see if I can get it. So if I get it, I will let you all know.
Perfect. Thank you.
It looks like a number.
Oh, go ahead. Sorry.
It looks like a number of folks have appreciated the presentation and are interested in asking more questions and sending more questions, and so I'm very thankful that so many people participated and asked so many questions. Are there any other questions you'd like to be able to answer at this time, Kim or Rochelle? And as you're looking at the questions, I'm just going to make one more announcement about the handouts. A number of people asked about the handouts. They are attached to this webinar, and I recommend you download them as soon as possible if you have not already downloaded the handouts, because it's only accessible during the webinar. So anyone who's still on the line and hasn't downloaded the handouts, please download them before we log out and answer these last couple of questions and say our goodbyes. Okay, go ahead.
I think, I would just encourage folks, we do have on our websites there's an ability to subscribe to newsletters. It's a CCR newsletter, and if on our CCR website, we have information about how to do that. We oftentimes have a lot of great trainings or webinars we provide information for through that, some oftentimes changes. It's a variety of things. It's our CCR subscription has a lot of providers on there, STRTPs, families, but there is a lot of great information that comes through that subscription. So I can't, I've closed it out on accident, but do we have on our how to access the CCR website, which would have the information to subscribe on there?
Yes, I shared the CCR website in the questions section of the webinar.
Great.
For every day.
And I have the and just for folks who may be newer to all of this, CCR stands for the continuum of care reform, and that is really the overhaul of the child welfare system where RFA was incorporated and, stepping kids down from group home care into more short-term intensive therapeutic centers, which are the STRTPs, which are the short-term therapeutic residential, ST, short-term therapeutic residential treatment program or therapeutic program, where kids receive intensive services and then who are hopefully able to step down into a resource family home. And I also have, you're welcome, and I have the CFT email box. It is cws coordination@dss.ca.gov.
So I have two final questions I'll send out. One is about allowance. Do either of you know about age-appropriate allowance for teenagers?
That's a great question. I would say that if you are associated with an FFA, I would talk to your FFA about what their standards are. And in fact, FFAs actually had been, many FFAs, not all FFAs, already had a policy of giving young people allowances. But there's some great information online about how do you determine that. Some folks would say like 50 cents to $1 for every year of age. So a 10-year-old would receive $5 to $10 per week, for example. And again, the reason why this came to be is around a young person in foster care really not having, many foster youth leave foster care without financial literacy, and in a huge disparity compared with youth who weren't in foster care. So this idea of allowance is also about teaching young people financial literacy. And if you think back to raising children and what that means for little kids, right? You're giving them a piggy bank and teaching them to put their money in their bank and save it. And when you're, 5, 6, 7, you're having lemonade stands or, taking on mowing the lawn. And then as you get older, babysitting, right? These are all the ways you learn how to earn money, save money, and appropriately spend. So that's the thinking behind the allowance. But again, 50 cents to $1 for every year of age is one of the things that I saw most frequently cited in the literature.
Thank you. And then the last question I might want to send out is, does the change in permanency affect a foster youth's rights? There were a couple of variations of this question, whether foster youth, who was considered a foster youth, are kinship youth considered foster youth, are guardianship youth considered foster youth? If you adopt a child, do they lose these rights? And if who has these rights, and do they lose them at a certain point?
So once an adoption is finalized, the foster youth rights no longer applies. When a child moves into a guardianship and is no longer under the jurisdiction of the court, the foster youth rights no longer apply. The foster youth rights apply to any child who is in an open dependency case placed in out-of-home care. If you are in the home of your grandmother, for example, and you have an open dependency case, even though you're with your relative and it's a kinship placement, those rights would apply to that child because they have an open foster care dependency case.
Thank you very much for answering all of these questions today, Kim, Kendra, Rochelle, and thank you, Andrew, for leading us in the website. And I think every single caregiver and support services provider, every social worker on the line who came today. I appreciate what you're doing, and thank you for joining us for this webinar. You will get a video of this webinar in your email. Have a wonderful afternoon. Bye-bye, everyone. Thank you.